More Americans have been killed by guns in peacetime than in all the armed conflicts in U.S. history combined, and yet, surprisingly, most gun advocates claim that they own a gun to protect themselves and their families. They overlook the fact that in the last 40 years in the United States, having a firearm in your house makes you more than twice as likely to be a murder victim and 3 times as likely to take your own life. While all murders defy any standard of common sense, the proliferation of mass shootings in recent years is particularly insidious and incomprehensible. A mass shooting is defined as a single shooting that kills or injures 4 or more people. In the U.S., in 2015, there were 372 such shootings, resulting in the deaths of 475 people. The number and scale of those shootings, while impossible to stop completely, could be drastically reduced if the sale of assault-style weapons to the general public were prohibited. In 1999, a friend of mine committed suicide with a shotgun while at his family's cabin in Luck, Wisconsin. Seeing how the misuse of a firearm affected so many lives made me question the logic of people who feel that access to firearms somehow increases their personal safety. It also made me take a closer look at the Second Amendment and question those who attempt to use it to defend their right to own assault weapons. Looking deeper into the Second Amendment and what it means involves understanding first what the Second Amendment says and how it should be interpreted, and also the acknowledgement that it does not explicitly enshrine the right of U.S. citizens to purchase any type of firearm. The Second Amendment reads a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. The Second Amendment is intended to apply to the ability of the states to form a well-regulated militia, which stems from concern that a standing federal army could threaten the security of individual states. The protection it describes is extended to military groups, not to individual citizens, and nowhere in the text is it explicitly stated that the people have the right to own any type of firearm they choose. The types of weapons it is intended to cover are those that are in common use for lawful purposes such as self-defense. And though assault-style weapons would admittedly be useful in self-defense, they do not satisfy the common use requirement. The Supreme Court has ruled on many occasions that none of the rights in the U.S. Constitution are absolute. For example, your right to free speech does not allow you to shout fire in a crowded theater, nor does your right to unreasonable searches and seizure exempt you from going through airport security checkpoints. For more than 200 years after the adoption of the amendment, the federal judiciary uniformly interpreted the Second Amendment to not impose any limits on the states themselves to regulate gun ownership. The perception that the Second Amendment can be interpreted to mean that the right to gun ownership is unassailable largely stems from the propaganda campaigns initiated by gun advocacy groups whose intent was to mobilize voters to elect government officials sympathetic to their cause. Political campaigns by organizations such as the NRA have perpetuated misunderstanding of the Second Amendment and led to 2 Supreme Court decisions that have altered the interpretation of the Second Amendment. The first is the 2008 case of the District of Columbia versus Heller, in which the Supreme Court voted 5-4 that the Second Amendment protects a civilian's right to keep a handgun in the home for purposes of self-defense. And the second is a 2010 case entitled McDonald versus Chicago, in which the Supreme Court decided that the Due Process Clause of the 14th Amendment limits the power of the City of Chicago to outlaw the possession of handguns by private citizens. And while neither of these cases pose any explicit obstacles to a ban on assault-style weapons, they do impose limitations on the states to pass laws that restrict availability of firearms, which sets a dangerous precedent for future cases regarding gun control. Existing laws and common use requirement prohibit the access of the general public to weapons capable of causing mass destruction for the same reason that you can't yell fire in a crowded theater, and that you must consent to search before boarding an airplane. The right of the public to legally be protected from the potential of injury or death from weapons of mass destruction supersedes the scope of the Second Amendment's protection of individual gun ownership rights. In the 12 years since the assault weapons ban was allowed to expire by a GOP Congress on September 13th in 2004, the number of mass shootings in the U.S. has increased by over 2.5 times. If a ban on assault-style weapons were passed, it would provide a legal scaffolding to hold those who sell or own these weapons legally accountable, and ultimately limit the number of assault-style weapons in the hands of mass shooters, and reduce the frequency and severity of mass shootings in the United States. The Bill of Rights provides protection for many of the freedoms we enjoy in this country, and it is important to interpret those freedoms as broadly as possible. Even in the broadest sense, the question of the average citizen owning assault weapons in the U.S. does not address the common use requirement, and therefore does not deserve the protection afforded by the Second Amendment. Although it will not prevent all gun-related tragedies, a ban on assault weapons in this country would be a first step towards acknowledging the loss suffered by the families of the victims of gun violence, and send a message to special interests and lobbyists that we are better served by laws that preserve the sensible than laws that protect the senseless.